Well, welcome back here on the Senior Network. We're having a great time as usual talking about pets, but made me think of some other things you were talking about earlier about wills and intangible, tangible, those types of things. So tell us a little bit more about how all this relates.
Sure. Well, we were talking about pets, and certainly somebody wants to take care of their pet. They want to make sure it gets to the right person. You probably want to leave that pet to someone in your will or your trust.
Right.
And you could even set up a pet trust and make sure there's resources to take care of that pet. And alternative people to take care of the pet as well.
Sure.
There's certain things you cannot leave in a will or a trust that you might want to write separately, or that maybe you'd be better suited to leave those things separately. An example might be what we call tangible personal property that can be left on a memorandum, which is mentioned in your will and is part of your will, but it's a separate document entirely.
Okay.
And I want to talk about that for a few minutes.
Sure.
Tangible personal property in its most basic form is something other than real estate. So instead of real property, it's tangible personal property.
Right.
But I want to narrow that just a little bit more. Most of the time when we talk about tangible personal property and things that someone wants to leave on a memorandum to people, we're talking about items such as jewelry. You were joking earlier about jewelry on her wrist making noises in the camera. But if you wanted to leave a special ring or piece of jewelry to a particular individual, you could do that on your tangible personal property memorandum as long as that memorandum is mentioned in your will.
Okay.
Actually, this past week I was looking at a will that we didn't prepare, and the client came in and they showed me their will and they showed me their tangible personal property memorandum, and I looked at both and I said, well, your tangible personal property looks like it's in order on your memorandum. However, your will doesn't mention it. So guess what? Your tangible personal property memorandum is meaningless. It means nothing because it was not incorporated into your will by reference. So you want to make sure in your will that there's a reference to that memo.
Sure.
And we were joking off camera a minute ago. The best part, I always tell clients, the best part about a tangible personal property memorandum is you don't need to come back to see me to fill it out or pay me a dime to fill it out, because it's something I'm going to provide to you out of my office, and most attorneys will.
Right.
And you fill it out and add to it over the years. Now, there's certain things you cannot leave on that memorandum, and the instructions are on the document that I provide to clients as well. You can't leave cash to people. As you can imagine, there's good reason for that. This is something you're filling out on your own somewhere else. Someone could modify that easily.
Right.
Yeah, leave an extra $10,000 to me and write that in, and that doesn't work very well. So we can't leave cash on it. You cannot leave items of a trade or business on it to someone. So if you had an automobile or a building or something like that that's part of a business, you couldn't leave that to someone. There's other things you cannot leave on that tangible personal property memorandum, but there's many things that you can. Commonly, people would leave things like a coin collection or a stamp collection, a gun collection, things of that nature. You would not leave an automobile on it or a boat. That wouldn't be allowed. Those types of things, items of title, you wouldn't leave on a tangible personal property.
Now, on this memorandum, is this something that you do yourself, obviously? Do you have to have it notarized or anything?
That's a great question. There's two basic rules. First of all, well, three basic rules. The first one is talk to your attorney about it to make sure you get it right, because if you mess it up, it has no legal effect at all, and you want to make sure you get it right. The second thing is you want to make sure that it is signed and dated at the bottom, and it does not have to be notarized. It does not even have to be witnessed.
Wow. Okay.
However, keep in mind that as a general rule, you should be putting this in your own handwriting.
Okay.
So the document itself,
in case there's a question,
and honestly, our rules under our statutes don't even require it to be signed and dated if it's in your own handwriting, but I would strongly advise that it be in your own handwriting and that it's signed and dated at the bottom. But you can add to it over the years. That's the beauty of it. If you go out and you get another special piece of jewelry that you want to leave for your daughter or your granddaughter,
just add it to the list.
You can add it to the list. You don't need to sign it and date it again. You've already done that, but you've added it to the list over time. And again, it does need to be incorporated into your will by reference. And so you just add to it over the years. And frequently people want multiple pages, so that needs to be worked out as well with your attorney to make sure that it's what you want. And frequently also, you may have multiple memos over the years. You want to make sure that it all coincides one with the other, so that if you sign and date a new one, you may be superseding the old one. You want to make sure that you're not doing that inadvertently.
Very, very intriguing. And I know, Becky, you see a lot of this too. I mean, we go into homes and there's just so many folks that don't realize. You see handwritten notes or wills or things like that. I mean, do those things really hold up?
You know, it's funny. Our neighbor to the north, North Carolina, they recognize what's called holographic wills. Wills in handwriting, and we don't recognize that in South Carolina. You do have to go through the process, 2 witnesses, and it doesn't have to be notarized, but 2 witnesses to the document, and there's some other stipulations and some ways you can stay out of court with the way it's witnessed as well, and that's always important to think about and talk to your attorney about as well.
And very good point. State to state's different, right?
It's very different, and I always tell folks, if they're new to the area, make sure that someone reviews your documents to make sure they're in compliance and will work out the same way in South Carolina as they did in other states. Because what I tell people is, if a document is executed in another state and it's proper there, it's going to be proper here in South Carolina. It's going to be respected here. Sure. However, it may not turn out the same way. It may not be interpreted the same way. Or the best part is, I tell folks, you know, it's fine. You have a document. It's valid here in South Carolina because it was valid in Ohio or Pennsylvania, and it's valid here. However, do you really want to hire an attorney back in Ohio or Pennsylvania on your death to help administer your estate here in South Carolina if you're a resident of South Carolina? Do you want to hire 2 attorneys when you really only should be hiring 1? And the answer is usually no.
Right, exactly. You want an expert in your area.
Right,
Sure.
and in the state of South Carolina, if you're going to be a resident of South Carolina, you need to have your documents proper for South Carolina.
Very well understood.
Yeah.
Becky, do you ever get involved with that at all when you're moving people in?
We do require when you move in a copy of your power of attorney.
Okay, right.
Healthcare directives.
Right.
That sort of things. We wouldn't have those on file.
Sure. And as far as wills and so forth, that's
yeah,
all personal business.
no. And then we do help. We do help if there is an estate involved. We do help them with disposing of the estate and things like that. But it's funny when you were talking about jewelry and things to leave. I'm like doing an inventory list in my head. I'm like, oh, I better make sure that person gets all my camera equipment. I don't want my brother getting,
Exactly.
Yeah, so you start to think about, and you do have a lot of things that you want to go out to. We're so complacent about things like that. You really do want to make sure it gets into the right hands. So
well, guys, I'm sorry. As usual, our time is up. We start
fast.
having so much fun. But thank you for joining us.
Thank you for having us.
And thank all of you for joining us here on the Senior Network, where senior care experts come together. We'll see you the next time.